What I want to speak with you about is leaving your inheritance to your children through the use of an irrevocable trust. And so when you pass away, you can set up either through your living trust or through a will, you can set up irrevocable trusts for your children to inherit that property. Now they could be the trustee of that trust, so they have the checkbook, and also be the beneficiary of that trust. But the reason for doing it is that all of the funds in that trust have what we call divorce protection. It's never going to pick up community property characteristics, and more so, the capital gains achieved on those assets are never going to pick up community property characteristics. So if there is a divorce, the divorcing spouse cannot claim that part of what's in the trust, part of what you left them, is community property. It belongs to your son or your daughter. Now, there's also protections for lawsuits and creditors. But on a more personal note, really what I want to talk about today is the impact that that can have on a marriage, because there's instances where people have apprehension about setting up a legacy trust for their child because they're fearful that their son-in-law or daughter-in-law won't think that it's fair. They'll think that it's unfair that everything was left to your son or daughter and they didn't have any benefit at all. And especially if you have a great relationship with that son-in-law or daughter-in-law, which is often the case. Okay, so there's nothing wrong with leaving assets to your beneficiaries, to your descendants, in a protected manner. However, it's also recommended, I highly recommend it, and this is something that I've obtained through personal experience with my family and with my wife, is that you have to express to your son or your daughter, your beneficiary, whoever is inheriting that legacy trust in a protected manner, talk to them about the importance of not holding that money as leverage or power over their spouse. Yes, it is protected if there's a divorce, but it shouldn't be used as a tool of coercion, and that could be detrimental to a marriage. Now, if there is a firm understanding of this and open communication, then why not have the best of both worlds? Leave the assets to them in a revocable trust. Let your son or daughter withdraw funds as he needs it for his benefit. Odds are your son-in-law or daughter-in-law is also going to benefit from that. And as long as they're married, that's great. However, if there were a divorce, most likely you would like to see your assets stay with your descendants or down the path that you originally planned. And so there's a little bit of a balancing act that you have to express to your children. Don't use this as a tool of leverage, but use it as a benefit to your family that is protected. And this is your legacy that you're leaving behind. And a lot of times you do want your son-in-law or daughter-in-law to benefit from it. And they will if your son or daughter is benefiting. As a married couple, everybody will benefit. But it avoids awkwardness, and there's no reason to feel bad about yourself about providing those protections to your kids. And so I hope that helps on a personal level. It's something that I actually had to learn through a little bit of trial and error, that the wrongs of holding a position of power because you have more wealth than your spouse, it will damage the relationship, and it can be avoided. So please talk with your beneficiaries about it, that this is a great thing that you're leaving them, and it's a great thing you're leaving their spouse, because they're going to benefit. But it just has to be treated appropriately. I hope that's helpful, and I appreciate you watching today. Again, I'm attorney Chris Brown with the Bond Law Firm. If you have any questions or would like to come in for a free consultation, then I recommend you please give us a call. Thank you very much.